We're going to move on to our first and only bill, which is Senate Bill 2 by Senator Cloud. So if you're ready, Senator Cloud, on your bill.
Am I on?
You are now.
Okay, thank you so much. Thank you, members, for coming to hear this bill this morning. This is very important legislation. It builds upon successes that we've already achieved that are critical to the overall well-being and safety and security of our state for today and for future generations. There are significant limitations regarding juvenile court jurisdiction that hampers the legislature's ability to enact proper and necessary reforms. This proposal provides the legislature with the authority and maneuverability to make critical reforms. I am proposing the legislature amend Louisiana Constitution Article 5 of the legislature, Section 19, to remove the outdated, cumbersome limitations. It is my understanding that these current limitations were put in place at a time long ago when our juvenile system dealt largely with nonviolent status offenses and minor crimes. However, we all know that our current juvenile system looks much differently than it did long ago, with increased level and severity of crimes committed by juveniles. Fortunately, the statutes already address mirrored language that is found in the Constitution regarding serious violent crimes that can be considered for transfer for prosecution into adult court. So that's what we're looking at right now, is just removing the language that is mirrored in statute currently, but it's also found in the Constitution. So that is what, Senator Abraham, that is what is causing the maneuverability, is the fact that it's also found in the Constitution. So we cannot add or take away as needed. So we're not changing the law. We're simply removing its antiquated and nearly immovable nature that it has because it's locked down in the Constitution.
Okay, Senator Abraham for a question.
Yes, thank you, Mr. Chairman. Can you give me an example of why we need to do this? Give me kind of a real life example is what I'm trying to, I guess, understand here. I understand what you're doing, but give me an example of how it would apply.
Well, there
by taking it out.
When you think of certain very violent offenses that would be adjudicated as a juvenile, that should and could be adjudicated in adult court, because it's in the Constitution and because it's written in statute, they're not transferable. Some offenses are not transferable to adult court right now. So this would allow us, it's not going to change the law, this would allow us to, if we need to in the future, add more offenses that would be serious, violent, and worthy of transfer to an adult court. The legislature could in the future statutorily address it.
Okay, so but currently it says by 2/3 vote of each house to provide that special juvenile procedures not apply to juveniles arrested for these following offenses. So if they are arrested for these offenses currently, it does not apply unless the legislature by 2/3 vote says it does. Is that how I understand?
If they are arrested for these offenses that are currently listed in the Constitution and in the statute, then it does allow for transferability to adult court, these offenses and no others. But since then, there have been new offenses, and we want to give the courts the ability to be able to transfer legislatively if we choose to address that in future sessions. We want to give them the ability to be able to prosecute as they see necessary.
We're still going to have the 2/3 vote, though, the legislature.
We won't, because it won't be in the Constitution. It would be a simple majority vote to add crimes. But again, this is not what we're not changing the law right now. That is not what this bill does. The only thing we're doing is taking it out of the Constitution, and we're leaving the law as it is in statute.
Well, look, I'm a co-author, so I need to jump in here. It doesn't change the requirement of a 2/3 vote to provide that special juvenile procedure shall not apply. That is not struck through. If you look on page 1, line 14. So there's still a 2/3 requirement.
So there still is a high margin then.
Right. There's still a high bar to change it. But But currently, under existing law, Senator Cloud, we have already put these things in statute, so this won't change the existing law
Yes.
per se. It will just allow the law to be changed by a 2/3 vote.
By 2/3 vote.
Right.
Thank you for correcting me.
Sure.
So, in other words, you could have an expanded list of those 15 if you wanted to, if this amendment passes.
Correct.
Okay.
Correct.
All right. I understand it. Okay, thank you.
Yep, sorry for the confusion.
Senator Barrow for a question.
Thank you, Mr. Chairman. Thank you, Senator Cloud. Can you give us an example? I was waiting to hear an example of like maybe a situation that may apply in this situation. Do you know of one, or is there something? So what led you to bring this particular piece of legislation outside of the fact that you wanted to extend it? Is there a situation that you felt that could not be addressed that this would allow to be addressed?
Well, I think we've been considering situations such as carjacking, a severe account of carjacking. We've considered that in law as a very violent crime. And as I'm aware, unless you can tell me different, Senator Morris, under the current law, that particular crime could not be transferred to an adult court. And I know that that's a very serious issue that's going on in New Orleans. Now, that's only if this legislature or one in the future would choose that to add it to the list of crimes. And this has come up multiple times, Senator Barrow, by other legislators on both sides of the aisle that have tried to address this statutorily during session, even during the crime session and last year's legislative session. I know Senator Katrina Jackson Andrews had tried to address it statutorily, only to find the limitations in the Constitution that she couldn't address it statutorily because it would require a constitutional amendment. So this would give us the maneuverability as a legislature in the future if we wanted to.
So this bill is similar to the bill that she was attempting to bring last session?
I think it has the same purpose. I don't know exactly what her language was. I just remember she ran into the constitutional limitation. She couldn't address it statutorily.
Okay. All right, thank you.
Yeah.
Thank you, Senator Barrow. Just another crime that came to mind as you were talking is sex trafficking, which is not on this list.
Yes.
Which is a pretty serious offense. But in any event, it remains to be seen if your bill makes it through and the people vote for it, whether the legislature will put up the 2/3 needed to do so. Well, we do have some cards. We have one from the administration. Chris Walters is here, I think, or he's got a card in. If you would come to the table and just, maybe explain it to it. I know you're a criminal lawyer or former criminal lawyer, and you might give us a little color on it.
Thank you, Chairman Morris. Good morning, members. Christopher Walters, Deputy Executive Counsel for Governor Landry. I think Senator Cloud did an excellent job of explaining just the flexibility that this provides to the legislature to be able to address and adapt our code to account for these instances in the future without having to go through a full-blown constitutional amendment every single time we want to make a change or either add or subtract a specific crime based upon what the legislature sees out there in the real world in their experience. And as Senator Cloud said, some of the specific crimes that are not included are things such as carjacking, assault by drive-by shooting, aggravated criminal damage to property, which is where someone like aggravated arson, for instance, where someone sets fire to a building where human life is reasonably at risk. These types of serious crimes, and Senator Barrow, to your point about any specific instances, I can tell you that we have seen some very serious assaults in OJJ facilities by individuals that are 16 years old that cannot be prosecuted in adult court. So if they are 16 and they have a juvenile life sentence, for instance, that individual would just continue to get another mark on the list of juvenile crimes that he really has no consequence for, because he can't get any more time than he's already getting, and so there are no more consequences that can be had. With that being said, I will tell you that there's many different ways that the legislature can address these types of crimes, and when they're committed by someone under 17, that does not include giving them the full penalty that's in adult court, if that's something that the legislature wanted to consider. Should this amendment pass and pass from the voters, then the legislature can make that determination at a later date.
Thank you for your testimony. We do have a question from Senator Barrow.
Yes, not so much a question as much as a statement, and I guess it's really ironic that yesterday we went to visit LCIW, the Women Caucus did, and while we were there, we saw 2 juveniles that were there who did commit a very heinous crime. My concern is this, and I want to make sure that I say this in a way that I hope people can actually get the context of what I'm saying. I'm concerned because the example that you use of a 16-year-old, what I would like to know is what led to that, because it's hard for me to believe that people are born bad. I don't believe that. I believe that bad things happen, and then when there's no positive interaction in their lives, and it just continues. And so, and I don't know, some people just, some things can't be fixed, and I recognize that too, and there has to be consequences. I understand all of that, but then some situations there are other things that lead to it, and sometimes young people get caught up in dumb stuff, and it's not a dumb crime. I'm just saying they do dumb stuff, and then it leads to a path that they can never turn back. I just want to be careful in what we're doing and how we do that, because one of the people I heard did not know what was going to happen, but she was there, and guess what? She got the same consequences. So those are the kind of things that I just want to be careful of, because as we see more of our children being born today with a lot more challenges than we had coming up, and not having the family structure that many of us had, they are coming up in situations that they cannot control, and then it just comes down to survival. So I just wanted to say that because I think that's important, and as we move forward, we need to keep those things in mind.
I just want to speak to that, Representative Barrow.
Senator.
Senator, oh my goodness, thank you. I spend and have spent, especially in the interim, I spend so much time in our juvenile facilities and in our women's facilities and in our male facilities, like in juvenile facilities and in DOC facilities. I know exactly what you're saying, and I think that, with the measure that we're proposing, or all the measures that we propose of consequences that we do, truly want to address while we have them in our grasp, and while we can at every level, when we notice truancy issues all the way through, we want to address those things as quickly as possible, even whenever they're adjudicated and serving in our custody, to change and redirect their lives. So I completely agree with you, and continuing to think through and work on that, because I talk to these kids. I mean, I talk to them constantly. I try to understand what they've went through and what led them, to the choices that they made. And at the same time, I understand that for the most violent of offenses, there has to be very serious consequences, because law and order at the same time has to be maintained. And I think that this gives us the ability to continue to address the law and order part, as we continue to work as, brothers and sisters trying to address the love and redirecting their lives part.
The only thing that I struggle with is when you say law and order, and I know that we have to have that, but when you're dealing with kids, because I do not believe the kids are born bad. I just don't. But a lot of things happen to kids starting very early. I worked with a counselor, and I'm telling you, I saw situations that were unimaginable 20 years ago, and it's gotten worse. unfortunately. And so kids have to try to survive, and it's not their fault. They're born in situations that they cannot control. And so anyway, I get what you're saying. I just didn't like the law and order part, but I do understand. Thank you. Thank you, Mr. Chairman.
Thanks, Senator. Thank you, Senator Barrow. Senator Abraham for a question.
Yeah, just
If I can.
one more bite of the apple. I think what you're doing is good. I have no problem supporting the bill. I just want to kind of delve in. Maybe, Mr. Walters, you can answer it. Tell me, again, in a practical way, when you find someone, a juvenile that's done aggravated rape, for example, so what's the procedure to go to the legislature to say 2/3 vote says you can charge him as an adult? What's the procedure?
Currently
How does that
now?
work? Yeah.
So aggravated rape.
Well, even on this new one, you still have to come back to the legislature for a 2/3 vote.
Correct. So essentially, the statutory law right now mirrors the constitutional provision that currently exists. So all of the crimes, the constitutional provision says these specific crimes, the legislature can vote by 2/3 vote to make these crimes transferable into adult court if committed by an individual under 17 years old. The legislature has already done that for the specific crimes listed in the Constitution.
Oh, so right now, these ones, you don't have to have a 2/3 vote. We've already passed that.
They're already.
Okay, that's what I didn't understand.
Yeah.
I thought maybe each individual case, you got to go to the legislature and get 2/3 vote. No, that doesn't how it work. That's not how it works. So all of these have already come before the legislature for the 2/3 vote. So now we're saying that if there's a carjacking now, that would have to come to the legislature for 2/3 vote. And
That's
then that would
correct.
cover carjacking from that point forward.
That's correct.
Okay, I understand now. All right, thank you.
Thank you, Senator Abraham. The board is clear. We do have some, sure. Senator Barrow?
I just really quickly. So when you just say carjacking, if no one gets hurt, but their car has been jacked, it would still the same level of the law would apply.
If the legislature
If we
passed
it
later,
yes.
I think that's something that the legislature could make a determination on if
In terms of the scope and the level of punishment.
Correct. Yeah. I mean, as far as that goes, once the legislature has that authority to make those determinations, then, the bill can be brought and debated upon. Is it all instances of carjacking? Is it carjacking that includes bodily harm or, severe emotional distress, whatever the case may be? And, you can tailor how you want to do it.
Thank you.
Yeah, and I would discourage just focusing just on carjacking because, like Senator Morris said, sex trafficking and drive-by shootings. I mean, those are very serious offenses too. When we think of carjacking, I realize that there's different degrees of carjacking. And correct me if I'm wrong, Mr. Walters, but even if it were hypothetically added in the future, that would still be at the discretion of the prosecutor, the district attorney, to be able to transfer it to adult court.
That's correct. I mean, the legislature can make those determinations as to, is it mandatory, is it discretionary, is there some discretionary component in it, however the legislature wants to address that.
Thank you.
Thank you, Senator Barrow. So the board is now clear. We have several people who want to testify. I'd ask everybody not to be repetitive of what other witnesses say. The first person I'm going to call up is Jack Harrison, who put in a white card with the LSU Law Center. Mr. Harrison, if you would give us your testimony, please, sir.
Good morning. Thank you, Senator Morris. So I just wanted to address a couple of the impacts, the practical day-to-day impacts that this bill would have. It would authorize a streamlined process for adding charges to Article 305 in the Children's Code. It would make it much easier for the legislature to do that, even with a 2/3 majority. What happens when a youth is arrested for any charge, whether it's transfer eligible or not? They enter a detention center. They have, within 3 days, the right to a continued custody hearing at which probable cause is one of the parts of that hearing. It's one of the prongs. Probable cause is the trigger for those charges which are currently or could be added is the trigger for transfer to the adult court. What happens is, and of course the district attorney's offices, the defense attorneys all take those cases very, very seriously. And so the defense attorneys in those cases will delay that continued custody hearing, so they won't have it within the 3 days that they're statutorily allowed. They'll ask for a continuance, typically for about 30 days, so that they can investigate, they can develop mitigating information, and they can engage in negotiation with the district attorneys. And so what that means is these young people, of course, remain in the detention centers pending that continued custody hearing, because that continued custody hearing is also when bond is determined. So the average length of stay for those youth who are arrested for transfer-eligible offenses is much, much greater than for youth arrested for other offenses. And so as you add to this list of transfer-eligible offenses, you're adding to that average length of stay in any detention center. And so the average daily population is going to rise as well. And I know this body has been very concerned with the population, the average daily populations, and overcapacity in the detention centers. I don't have the data about the average length of stay for the transfer-eligible cases. I think maybe Joey Dominic, who's the executive director of the Louisiana Detention Centers Association, may have that data, but I know it would have an impact on all of the detention centers. I know Tony Celestine in Lake Charles, who is a wonderful administrator of a detention center, is going to be significantly impacted, and the programming that he has in place for his youth will be detrimentally impacted. Now, there are some...
To be clear, he wouldn't be detrimentally impacted if this bill passes.
Well,
only if we come back and we put a whole bunch of crimes
yes.
Onto the list
and
that provide for transferability. But if we didn't do anything, this bill in and of itself doesn't do that.
That's correct. If there were no offenses ever added, then this bill would...
And if there were, if the legislature were very circumspect and diligent, they might not add a whole bunch of offenses, I would guess. Can't be sure, but if you're going by 2/3 vote, it might only add just a couple.
Well, that's true. And historically, I know that none of the offenses that have ever been added to 305, either A or B, no offenses have ever been removed. And so I also look at 14.2, the violent offenses. That list has grown significantly over the past years, and I don't think offenses are ever removed from that either. So I anticipate that over time, it simply would build and would never be decreased. So I think, and it may take some time, but I think there certainly would be some impact, particularly when the legislature is responding to what is perceived as a growth in certain types of offenses. So if that data is borne out and the response is to recurring offenses, then that in itself, I think, would cause an increase in that average length of stay and average daily population. Okay. Now, I also recognize that there are some benefits to the youth who are transferred, and that is they do receive the benefit of more robust constitutional protections. I think having jury trials for a greater number of youth could be beneficial. I think the current adjustments to the confidentiality provisions of the Children's Code notwithstanding, I think having public proceedings and having those kids and the proceedings involving them open to public scrutiny would be of benefit to the young people. And of course, young people who are transferred get the benefit of a much greater time frame for their cases. So those cases last a lot longer. The attorneys have a lot more time to do work, particularly when those youth are out on bond. They may have the same time frames that adult provisions would have. And so I think those sort of practical implications should be considered. There is, and Senator Abramson, you did ask about, I'm sorry, Senator Abraham, you did ask about the aggravated rate, which is currently in 305A. So that jurisdiction is automatically divested of the juvenile court on that finding of probable cause. So I just would ask this committee to consider those impacts, and it would be interesting to have that data from the detention centers to see what that average length of stay looks like for those transfer-eligible youth. Thank you.
Thank you. Thank you for your testimony. Okay.
Yeah, so since all these have been passed by the legislature, I don't know when they have, did you notice that big a length of stay when these were passed by the 2/3 vote? That would be a question too. How much really did it add to the length of stay? But anyway, we don't have that statistic now, but it would be interesting to know.
It has, but it's been a while since there have been significant additions to 305B. And so I think the average length of stay will increase when new measures are added.
Yeah, but if these have not increased that much, new ones coming along is probably not going to do too much. But anyway, okay, thank you.
Okay, that prompted another question. Senator Barrow.
Yes, thank you so much, Mr. Chairman. You stated that having the jury trials would be beneficial. So currently, they don't have that kind of process in place.
That's correct.
And so explain to me a little bit, because it seems like to me that becomes more public, right, as it relates to the information, the crime, etc. How would that work? Or how do you anticipate that working?
So any youth who is transferred to the adult system, their proceedings are public.
Okay.
And so they are entitled to a jury, and those proceedings are open to the public as it is. It's only those proceedings which remain in juvenile court, the proceedings themselves, except for the crimes of violence, for which the proceedings are open to the public. But for all other proceedings in juvenile court, they are not open to the public.
So we are talking about crimes of violence for the most part that may be added. So what would be the difference? I'm just trying to understand.
Well, the difference is they would have the right to a trial by jury in the adult system, in the adult court.
And you believe that would actually be a benefit?
For some youth, yes, certainly that would be a benefit. If I were an advocate and I have a 14 or 15-year-old client, I would certainly want a jury to see that child.
Mm-hmm. Okay. All right. Thank you.
Thank you.
Thank you, Senator Barrow. Thank you, Mr. Harrison. I'm sorry.
Thank you.
Are you a professor at LSU?
I am, sir.
Very, very good.
Thank
you teach criminal law?
I teach juvenile law.
Oh, really? And that's all? Or,
yes, sir.
Okay. Interesting. Okay.
Thank you.
I don't think they had that course when I was there.
They did not.
Okay.
They've only had it since I've been there.
It's ancient times. Thank you, sir. We've got several in opposition to the bill. So I'm just going to ask you guys to come up three at a time. And to start, let's see. Michael Cahy. I don't know. The Promise of Justice. There you are, sir. If you'll come up. And then we have Sherry Thomas with the Justice and Accountability Center. And we have Mary Lee Montgomery. If the three of you all would come up and give your testimony, please.
Could I by any chance go after Ms. Rowe?
I beg your pardon?
Could I by any chance go after Ms. Rowe? It's okay if not.
I can't understand. Which? You want? Yeah, you can go. If you want to change the order, that's fine. Whoever wants to come can come instead. So if each of you would give your name and give your testimony, please. You can start, sir.
Thank you, and thank you, committee, for listening to our testimony today. My name is Michael Cahoon. I'm from the Promise of Justice Initiative.
Cahoon.
We're a nonprofit that advocates for incarcerated people in their communities. I know there will be other testimony from people with far more specialty in this part of the law coming, and I think our position is just that when the Constitution was written and framed and the people voted it in, that they got it right, and that the Constitution is written the way it is with this high burden for a reason, and that reason makes sense. part of the presentation of the bill is that it is a very high and burdensome hurdle that has to be crossed to add transferable crimes. But I think it's worth mentioning that it's a high hurdle for a reason. It's because these are children who are getting sentenced as adults and being sent to adult facilities. I mean, that, I think, is such a serious departure and serious measure of our criminal legal system that the people have a right to have an input into which sort of offenses merit that extreme. And I know that the 2/3 vote of the legislature is being kept for adding new offenses. So in that sense, really the only change is that the voice of the people have been taken out of this process. And I think when this was drafted and voted on by the people, they wanted a say in the process because this is such a serious thing that can happen to a child being put into an adult facility. And, you know, it is, I think, a profound social failure when children partake in really violent behaviors, and that's why they're enumerated in the Constitution. But it's a real profound social failure when we have to give up on kids and send them to adult prisons. And I think we all bear the responsibility for making those decisions together. And these are still children. And, you know, just I will say that I know the Sheriff's Association is neutral on this. There will be impacts that Mr. Harrison and others will mention. But checking in with my sheriff's office, the OPSO in Orleans, they have a lot of burden already from the transfer of 17-year-olds that potentially, if more are added, could be seen an even further burden. And people are already being transferred, and children. There's a 17-year-old in OJJ or OJC in Orleans Parish Prison right now who is in on a $2,500 bond for theft of goods. 17 years old, she turned 18 in an adult jail because she couldn't pay the bond. So this is already happening. I think the high hurdle exists for a reason because we can't give up on our kids so easily.
Thank you for your testimony. Please, ma'am, if you go next.
Cherie Thomas with Justice and Accountability Center of Louisiana, also with Louisiana Stop Solitary Coalition. I definitely want to ditto the same thing that Mr. Calhoun said, but in the instructions of Senator Morris, I will not mention any of those things, but I do want to share our same sentiments of what Mr. Calhoun said. I also want to say that we are considering this for children prior to their 17th birthday. So with all of that taken into context, one of the things that Senator Abraham mentioned was aggravated rape. It is already included in the list that the proposed amendment looks to remove. And so it says that it's going to remove the list. So all of the crimes that you all have mentioned is currently in the list. So I think we really need to look at the list of what we're really concerned about because it's already listed in the list. So this amendment is going to move that and cause us to have new special procedures. Also, too, in regards...
Actually, just to be clear, this is already in statute, so it's not going to change the current law. Only if we pass a new law in the future would it change how these crimes are treated.
Okay.
Just to be clear.
So with the actual individuals currently right now that are 17 years old that are being incarcerated, there are limitations to where they can be held, and some of them are in solitary confinement. So what this could do is increase the number of juveniles that are in solitary confinement or in special housing areas where they're not getting programming. And I know myself as a youth, when I was young, I made dumb decisions. I made decisions decisions that I would never make as an adult. However, from those decisions, I was able to get therapy, loving people around me, and I think we need to consider that with our youth, not putting them off in housing where they can't get any programming, any therapy, and they need rehabilitation. So I want to make sure that these special procedures that we are looking to change, it's going to consider and still follow them to where they don't have to be placed in solitary confinement.
Thank you very much, Ms. Thomas, for your testimony. Yes, ma'am.
Good morning. I'm Kristen Rome, Executive Director of Louisiana Center for Children's Rights. I just want to clarify a couple of things that were said earlier in testimony. So Senator Cloud brought up carjacking a couple times. Many of these crimes that were brought up, drive-by shootings, carjacking, these are all covered by the enumerated crimes currently listed and that can be transferred. And we recognize that when a crime is severe and violent, that there should be consequences and that public safety does require that. Senator Abraham, I see you looking. I want to let you know that carjacking, when committed with a gun or harm somebody, is an armed robbery. So a young person can be transferred to adult court for an armed robbery when there's a carjacking. As it relates to sex trafficking, we already have every type of kidnapping as well as rape listed there. As it relates to drive-by shootings, those can be charged as attempted first or attempted second-degree murder. So those crimes that we are talking about, that again, we weren't given specific examples or data around how often we're seeing those and what limitations actually are there, we can see that they are transferable and they are being transferred. And I want to make very clear that I am not sitting here saying that when a crime is severe, that it should not be handled severely. I am saying that we already do it. And so there is no need to disrupt our Constitution to correct something that's not an issue. I will repeat some of what Mr. Cahoon said in a way, because I do think it is very important when touching the Constitution that we think about the framers and what the framers intended. And when the framers what the framers intended for our Constitution was not just protections for children, it was severe protections when we are inhibiting someone's liberty. And in this case, when we're talking about incarcerating children, we're talking about liberties. And so it does require us to put in a little more time to hear from the public. That is what the framers intended. And so if we intend to change what the framers intended, we need to be very thoughtful and clear about that. I want to also think about the fact that young people of 17-year-olds are currently tried as adults, and young people as young as 15 right now can be transferred to adult court. DAs do it all the time. What this amendment does is it removes all protections from the Constitution for young people, making it so that any legislator, once these protections are removed, can propose bills that will allow any child of any age to be transferred to adult court for any crime. And that is not what our framers intended when they wrote the Constitution. So I implore this committee to think long and hard and to not pass this because of the way it flies in the face of our Constitution. And then finally, I'll say, because these most severe crimes are already enumerated and transferable, to add other crimes that are less serious really dilutes the seriousness of what we already have. And it really sends forth a message that we don't begin to classify crimes as violent versus nonviolent. And it really does set us apart as saying that everything should be handled in a severe way. And so I just add that and offer that to the committee.
Thank you for your testimony.
Thank you.
If you all, we do have questions. Senator Barrow.
Yeah, I have a really quick question because I'm looking at page 3 after the list of all the crimes here, 15, and it says the proposed constitutional amendment removes the list of offenses contained here. So they will be removed. I thought maybe, Mr. Chairman, I heard that you said that they would not be. Did I misunderstand?
What lines are you talking about?
It's right after 15, and so it says proposed constitutional amendments removes the list of offenses contained in the present Constitution and provides that special juvenile procedures not apply to juveniles arrested for having committed any crimes provided by law, subject to authorization of the legislature by 2/3 of the House vote. So will this list then no longer
It won't be in the Constitution. It's already in the statute.
Okay. So then we will come back because all of this will be removed.
But the list, what you see struck through will be removed from the Constitution, but not removed from the law. But the statute is still in effect.
And then we can come back, though, right?
We can come back and add to the statutory list, not what's in the Constitution, but we can add to the statutory list.
But we
by two-thirds vote.
By two-thirds vote, yes.
Right.
But we would be actually removing all of these from the Constitution.
Correct.
Okay. Thank you. That's problematic to me. Oh, okay. Thank you.
Thank you, Senator Barrow. Thank you all for your testimony. If you would please make room for a few more we have that wish to testify. We have Reverend Alexis Anderson would like to speak, and Mary Lee Montgomery would like to speak, and Terry Landry Jr. would like to speak. Yes, ma'am. You can go ahead, state your name, and give us your testimony, please.
Sure. I am Reverend Alexis Anderson, and I am here on behalf of the East Baton Rouge Parish Prison Reform Coalition, and I am extraordinarily concerned about this piece of legislation. I am in the 19th JDC almost every day. I myself are one of our volunteers that are monitoring, and so we have already seen the impact of the reversal of raise the age. And I am concerned that we keep making artificial rules that don't apply to children being children. And a child's status is not based on what they're accused of. It is based on biology. It is based on their mental capacities. And I am very concerned that the legislature is responding more out of fear than accuracy. I'm also concerned as a citizen of this state that is looking at budgetary constraints as we continue butting heads against federal law. Where are we going to get the funds to keep putting people in these situations? We already have the ability to transfer children, quite frankly, with little or no restrictions. I don't think we need to add continual opportunities to penalize children because they are children. And at the end of the day, when we continue to find these ways to put children in places that adults don't thrive in, without the services that children are entitled to, because they don't get educational services, they don't get the mental health services, and they are subject to rape and other things in an adult facility in a way that even in juvenile facilities with all that is wrong with them do not apply to them. So I would ask this committee, we already have enough ways to mistreat children. Let's look at ways to strengthen early education, to strengthen our public education system, but not to keep figuring out new ways to demonize and sometimes put our children in some of the worst circumstances that they will not thrive, they will not succeed, but they will still be coming back to us. Thank you.
Thank you. Yes.
Good morning, folks. Marilyn Montgomery, Louisiana Progress. We've got a couple concerns about this bill. First of all, what it could do to the recidivism rate. We know that pre- and post-adjudication incarceration of juveniles increases the likelihood of reoffending and arrest for more violent offenses. And I know that, we have both the Constitution and the statutes, but in removing this list from the Constitution and making it so that you don't have to have a statewide vote to change the number of things that someone can be transferred for, you don't ask someone to move their bag if you're not going to sit there. You don't make it so that you can edit the list of statutes for which a juvenile may be tried as an adult at a younger age if you're not going to change the list. So just with that seeing that coming down the road, I feel like it's important to highlight the impact that this could have on the recidivism rate. And we see this nationally among non-incarcerated youth transferred to an adult setting. 39% were more likely to be rearrested on a violent offense. And at the state level, we see that juveniles on probation have a lower recidivism rate than those in what's deemed to be secure or not secure settings. So what we can conclude is that juveniles benefit from remaining within their communities, attending school, going to the diversion programs, and continuing to grow and learn from their families, from their communities. And this is, I think, what the Constitution, having this in the Constitution, requiring a statewide vote kind of gets to here, is that if we are taking these 16, 15, or younger, but I'm going to assume mostly 15 and 16-year-old juveniles, functionally freshmen and sophomores in high school who can't drive, are heavily reliant on their families, on their support systems already, and placing them in situations where they are more isolated from those support systems, we see that they don't do well. We know that juveniles are adolescents, and adolescents are more malleable. They are still impressionable, they are still growing, and we also know that 90% of the juveniles who have some sort of run-in with the criminal justice system have pre-existing trauma, have issues. So there's a lot of space for growth for adolescents in general, but specifically for the adolescents that we see going into the criminal justice system. And this is why the juvenile justice system is more gentle. It's more focused on rehabilitation as opposed to punitive measures that we see in the adult system. And so when we take kids from the juvenile system and put them in the adult system, effectively deciding that, the rehabilitative measures in the juvenile system aren't going to help, that these kids are, it's too much for that, we are kind of in a way turning our back on them. And I know that some of the previous presenters have gotten to this, but I think that it's important that families around Louisiana get to have and continue to have a say in what constitutes an offense so bad that we have to turn our backs on kids. Thank you.
Thank you for testimony. Mr. Landry.
Good morning, Mr. Chairman, ladies and gentlemen of the committee. My name is Terry Landry, Jr. I am the Policy Director for Southern Poverty Law Center, and I'll do my best to be brief. I share the sentiments of my colleagues, and I will try not to be repetitive, as Mr. Chairman has asked, but I think that it's important.
Well, we have another committee in a few minutes that a couple of us have to go to, so that's the only reason I was.
Yes, sir, not a problem.
But give us your testimony.
Yes, I think that it's important to note that just in February we were here talking about lowering the age to 17 years old, which this body passed. And all we heard were incidents of violent crimes. 17-year-olds were out of control. And I'm not here today to say that 17-year-olds are a problem in some instances. Some of them are committing heinous crimes. We're not justifying that. We are aware that, as Ms. Rome said, severe crimes need severe consequences. However, there have been several unintended consequences by that particular law. There was a report that came out last month that said over 69% of arrests of 17-year-olds have been for nonviolent crimes. And I don't believe that was the intent of this legislature. At least that's not what was portrayed or said in committee. And we can go back and run the tape. Many DAs stood and said 17-year-olds are these heinous crimes. That's what we're attacking, right? But we know that is not what's happening. That's not what's happening. We're having kids who are being kids that are unintendedly being affected by this issue. And so I think we're jumping the gun a little bit. I think it may be premature. We're stating laws based on what if. And if that's how this body wants to govern, then everything can be wide open. I've had the pleasure of being around this building for over 15 years now in some form or fashion. And normally what happens, or what I'm used to happening, is legislators ask, where's the data? Where are your examples of concern that shows that this bill should move forward? We have none on this issue. We're going on a maybe, what might happen, what we might need to see in the future. We just lowered the age in February, as I just stated. I think that we should wait, let that law play out. Let's see what data comes in after a year. Let's see what happens, what kids are being affected after 2 years. I don't think 9 months is sufficient to then jump in and say, now, we just lowered it to 17. Now we're going to consider anyone under the age of 17 for any crime, for something that might happen. And we don't have good examples, or we don't have any examples of why it's necessary or needed at this particular time. I think that we can do our children a better service than constantly focusing on what they might do and how they might commit a certain crime at a certain age. It's been said before, but I think it's important to say we have to let our children be children. We've talked to several organizations, and including Orleans Parish Sheriff's Office, who they're concerned about this issue. They're concerned because kids can't be separated by sight and sound like it's federally mandated. So as Ms. Thomas said, we're having to put them in solitary confinement. These are real issues. Kids are being shipped off, even here in Baton Rouge, they're having to be shipped off to Jackson, Louisiana, because the facility can't maintain them. And it's costing the state money. It's costing these cities money. I just think that we have to be aware of all these unintended consequences before we enact these laws. I think there's a time and a place for it. And maybe we can have some justification for some of these issues, but just to have a blanket statement that says any crime for any youth before they attain the age of 17, I think is going to be harmful to our communities. It's going to be harmful to our families, which is ultimately harmful to the state of Louisiana. So I would ask that you consider these consequences, consider these issues, and let's put a pause on this particular legislation until we have more information.
Thank you, Mr. Landry. Senator Barrow for a question.
Thank you. Thank you so much, Mr. Chairman. And I think you bring up a good point, Mr. Landry. Just as I was coming in the building, I met one of my colleagues, and I asked her which committee she was going to, and then she asked me which committee I was going to, and I told her which bill we were taking up. And she said to me, she said, this is killing my my sheriff department. She said they are spending right now $300 a day. She also said to me that they're trying to figure out a place where they hold the children, and they're looking at a hotel. And I was like frantically saying that is absolutely the worst thing that we can actually do. We are sending children who may have issues where they're going to be all congregated together at a hotel. That is absolutely horrible. So with that said, I guess I would like to go back to the data and actually having that information. And I'm going to ask the author if she has any of that data that she can give to us, because I think that we do need to make our decision based upon the numbers and being able to look back and see whether or not it actually makes sense, or if it's going to cost us a whole lot more money that we may not have. Thank you.
Thank you, Senator Barrow.
Thank you, Senator Barrow. Thank you all for your testimony. We have 2 more cards for people against the bill not wishing to speak. Stephanie Willis with ACLU Louisiana and Meg Garvey with LACDC, present in opposition but not wishing to speak. The board is clear. Senator Cloud, to close on your bill. If she's willing to take a question on closing?
No, I'm not taking questions on closing because of your obligations for your bill presentations and respect
well,
to
if we were short, it'd be okay, but
okay.
So it's your choice.
Thank you. You have heard the testimony. I will say the current proposal costs nothing, and the current proposal does not change the law. And I also want to say that if we were to consider changes in the future statutorily, the legislature could consider structuring any changes to allow for juveniles to serve their juvenile years in juvenile facilities and then be transferred at the age of majority to adult facilities. So there's a lot of caressing that we could do if we were to address it statutorily. Many states have flexibility and maneuverability within their statute and not tied in their constitution. And I think the testimony that we have heard for the years that we have been serving in this legislature as it relates to juvenile crime and the egregious nature of many of the crimes, and that is what we're talking about, the most egregious of all crimes, or what we're talking about, taking them out of the Constitution and giving us the flexibility and mobility to address them if we need to at a high margin vote, a 2/3 vote in the future. That is all that this bill is proposing. No law change and no cost increases. So thank you, committee members. I ask for favorable passage.
Okay, would you like to make the motion?
I'll make the motion.
Senator Cloud moves to report Senate Bill number 2 favorably. Is there an objection? Senator Barrow has objected. Madam Secretary, will you please call the roll? A yes vote, of course, is to move the bill favorably and send it to the floor. A no vote is to leave it in committee.
Senator Abraham?
Yes.
Yay. Senator Barrow? No. Nay. Senator Cloud?
Yes.
Yay. Senator Hodges? Senator Klein-Peters? Senator Miguez?
Yes.
Yay. Senator Morris?
Yes.
Yay.
4-1.
All right, the bill carries. It will be reported favorably. Thank you, Senator Cloud. Thank you, committee members.
Senator Cloud now calls Senate Bill 2 by Senator Cloud. It is a joint resolution to amend Article 5 of the Constitution of Louisiana relative to special juvenile proceedings, to provide relative to offenses committed by juveniles, and to allow adult prosecution for offenses provided by law. Senator Cloud sends up technical amendments made at the suggestion of a legislative bureau note and moves adoption of those amendments. Without objection.
Without objection. Senator Cloud, on your bill.
Thank you, Mr. President. Members, this legislation and proposition builds upon the successes critical to advancing safe communities, cities, and our state. We're seeking to remove from the Constitution language regarding special juvenile procedures and crimes that can be transferable from juvenile jurisdiction to adult court jurisdiction. And I want to be very clear, just so that there is no confusion, this does not change the law or its application, because the procedures and crimes and the 2/3 majority vote for change currently exists in law in the Children's Code, Article 305, Paragraph B, and it is near mirror language for the constitutional language that we are seeking to remove. This language has existed in the Constitution since the 1970s, and we all know that the landscape of juvenile crime and the crime rate across Louisiana has changed drastically since the 1970s. Catastrophically, in fact. In our research, this is an important fact, there is no other state outside of Louisiana that has such language of juvenile crime locked down in their constitution, only Louisiana. So this has hamstringed Louisiana from being able to address changes in an ever-changing juvenile crime landscape. This measure not only brings Louisiana in line with 49 other states, but it offers the legislature the ability to study and debate solutions for the most serious of juvenile crimes that have jeopardized the safety and security of communities, and decide through a 2/3 majority whether or not we need to make changes to procedures and crimes. Ultimately, I'm offering an opportunity for the people to decide through a constitutional amendment. And I see I have a few questions, I'm sure. Maybe more than a few, Mr. President.
Senator Barrow for a question on the bill.
Do you want to come on this? I'm all set up here.
Yeah, I see you have your list set up. Good afternoon, Senator. How you doing?
Wonderful, thank you.
Good. Okay, so in committee, when you first started presenting the bill, you shared with us that this bill was very similar to the bill that Senator Andrews had, I think, earlier this year during the regular session.
Is that a question?
Yes, you did, right?
What I did say is that I didn't remember the language of her bill, but that she's been trying to address some of the same issues. And she, in particular, was trying to address dual sentencing, which this would avail the legislature to being able to have that conversation.
Being able to, but it wasn't the same. Okay, so that's one of the things that I wanted to go to, because on closing, I wanted to ask that question. There was a lot that came forth as it related to testimony, and then you didn't want to take any more questions on closing. So I have a few questions that I wanted to ask then that I wasn't able to ask. So number one, have the sheriffs and the DAs actually supported this particular amendment?
Yes, ma'am. Actually, the District Attorney Association contacted me this morning, and they are in support of this measure.
Did they send something out to us?
I think that Mr. Zach Daniels said that they were going to be calling senators directly.
Interesting. I hadn't received anything, and I would have thought they would have called me. Okay. Number two, when we did the change to lower the age, that was last year, correct?
It was earlier this year.
Lowering the age.
Yes.
So
the crime
is
session.
Yeah. Right.
It's been a lot.
Yeah, it's been a lot
this year.
You're right. So is there any data that could substantiate the need to be able to do this at this time? Have you seen any data that show like we have an uptick in crime, that we have more offenses with juveniles? Is there anything that you've been able to base this decision and bring in this particular piece of legislation?
I can tell you, having not studied every single parish in the state, I can give you, case examples in my own parish, and I'm sure you could probably think of recent juvenile crime situations that has happened in your parish too. So juvenile crime has not went away, and the severity of juvenile crime has not went away, and something that I think societally, we live in a fallen world, Senator Barrow. We're going to always have to deal with these things and address them, together as a legislature methodically and carefully. But of course, I'm not changing anything currently. All I'm doing is removing language from the Constitution, not proposing changes to current law. So, of course, we're not changing anything. We're just availing ourselves to have those discussions in the future.
We are not changing anything, but we are getting ready to bring it before the vote of the people for us to take that right from them and then give it to the legislature to add additional crimes to the law.
Right.
Correct?
We are giving the opportunity for the people to decide whether or not the legislature should have the authority to address the...
I think that's what I just said, yeah. But going back to my initial question, is there any information, any data that you have that can say that this is something we need to bring back before a vote of the people to give us that authority?
I think if you probably read the newspapers, current news articles, and I can tell you, look, I'll give you an example. Just recently, probably 4 weeks ago, in Evangeline Parish in Ville Platte, we had juveniles pull, I have videos that I can show you, pull AR-15s out in the middle of a community from underneath their sweatshirt and just start shooting out into the street. And I can give you another example of just before that, months ago, maybe 2 months ago, juveniles pulling an AR-15 in my home parish out, shooting a vehicle as it passed by and killing a young lady who is also a juvenile. And so I would imagine that many of the senators could come up and then House members could do the same of giving you examples of examples on top of examples of
examples.
Of such
I understand, but there's no data. That answered my question.
No, it's reality.
There's no data, but you're giving me examples. So what led you to bring this bill again?
We have been having this conversation
during our tax. Well, let me rephrase that. What led you to bring this bill during our tax session?
Why not? I mean, it was
okay.
I had, of course, a right to bring a bill that I wanted to during
but
tax session.
I'm just wondering, during the tax, while we were trying to deal with our complicated tax structure, what led you to bring this bill at this time?
Well, this is a conversation that we've been having for a few years now on both sides of the aisle on how to deal with juvenile crime, and this is an overarching problem, having it locked down in the Constitution. The fact that we're having conversations about constitutional propositions makes it a great time to have a conversation about putting this at the same time on a ballot, because being able to bunch it all together at the same time would save the taxpayers. What did Senator Morris say? $12 million maybe for a statewide election. So this is an effort to bunch some of the more pressing issues that we feel would be a benefit for Louisiana in a cost savings way.
Well, I guess that's one way to look at it, but if you had brought it during the regular session, it could have been on the ballot in November.
It could have, or if we wouldn't have had any other constitutional amendments, it would have costed the taxpayers $12 million, and it maybe would not be implemented until 2026. So then we wouldn't be able to have the legislative conversation until 2026 because the people would have to vote for it.
Correct.
So that would be 2 years from now.
No, it wouldn't be 2 years.
Well, 2026, almost.
Well, no, not 2 years. It'd be a year. So one of the things that I heard you say was us being an outlier to the rest of the nation as it relates to what other states do. But are those other states leading the world in the number of individuals that are incarcerated?
I don't have that data with me, but I can tell you we're listed, our crime, statistically our crime rate is, pretty high, and we're working on whittling that down and looking too, as we often do, is what other states are doing maybe better than us that have come, where they've come out with some good outcomes. This is one place that we have found that other states do not have these provisions of juvenile crime locked in their constitution. And so we're just bringing Louisiana in line with other states. That's all that this bill is doing, in fact.
But unfortunately, we are leading the world in the number of individuals who are incarcerated. That number went down a couple years ago when we made a lot of changes to our, the way that we actually penalize folks, but that number is now going back up. I'm almost finished. Is this an attempt to charge younger children as adults for less serious offenses?
No, ma'am. I don't think that this is an attempt to do something like that. I think that this is an attempt for district attorneys, for prosecutors to be, if we would, first of all, this is an attempt to remove the language out of the Constitution. And those kinds of conversations on what crimes could be added and at what ages they could apply and what procedures, would be used, those conversations would happen after the fact if the people elect to give us this authority.
To do so. So a judge who is sentencing adults will now have the ability to sentence children as adults.
This bill doesn't change any of that.
But that's what would in essence happen if the people, if this amendment goes before the people and the people say yes, and we come back and we add the 14 things that are here in statute and law, in the Constitution, and add those along with any more that we would like to add, then a young person could be charged as an adult by charged as an adult by a regular judge, not a juvenile judge.
Yes, ma'am. This bill doesn't do any of that. This bill just takes the language out of the Constitution and retains it in statute. And the 15 crimes that you talked about maybe adding to statute, they're already existing in the statute in the Children's Code in 305.
It's already in there, but it's being done currently with a juvenile court judge, correct?
No, ma'am. Those are the laws that can be transferred right now if a district attorney, and that currently exist in law, so I'm not changing anything.
But we would allow this to go before the people who actually voted this to be in the Constitution and take this away from them and then give it just to the members of the legislature to decide what would be in the what would be in law.
The law wouldn't change.
But is that what would happen?
All that this bill does, Senator Barrow, is asks the voters whether they want to remove the language from the Constitution or not.
Remove these items.
Mirror language.
That's exactly right. Out of the Constitution and allow the members of the legislature to put it into law.
It's already in law. I'm confused because it's in law. It's already in law, yes.
But it would allow it be taken away from them and allow us to add other items to this as a part of the law.
If the legislature wants to have that conversation in the future to add items or remove items or change any procedures, then the legislature could have those conversations in the future. It does retain 2/3 vote margin on both sides in both
So
chambers.
Currently, if there is a change and there's something that will need to be added, it has to go to a vote of the people. correct? If we want to add a crime of violence. So let me ask this a different way then.
Okay.
It has to go before a vote of the people.
Yes, ma'am.
We are now saying we want to take that away. We're going to bring it before the people to ask them to allow us to be able to add additional items to the law to charge as crimes of violence to young people.
We would, again, this simply takes the language out of the Constitution, and it would avail the legislature to have those conversations. And for example, Senator Barrow, the legislature maybe would want to add sex trafficking to that list. And
the children can be charged for sex trafficking.
Other children.
Other children.
Mm-hmm. And then look, a district attorney would decide whether or not to prosecute them as an adult or not. This does not require them to be, nor does the current law, current statute, this does not require
I understand that. I just want to make sure that people understand what is happening here, because this is already in the Constitution, correct?
Yes.
Okay, make sure we got that established. What you're asking is an amendment that would go before a vote of the people that would actually take this authority from the people that's currently here, that would allow the legislature to add more crimes of violence without their vote. Correct?
This measure,
Yes.
no, I'm going to answer your question.
Okay.
This measure brings Louisiana in line with 49 other states by removing language from the Constitution, which the mirror language exists in law, and we are not changing law. It does avail the legislature in the future to have deliberative conversations with stakeholders on whether crimes should or should not be added.
Again, that's a nice way to say it, but
It's the way it is.
But the truth of the matter is, it's taking it out the Constitution. The people will not have an opportunity to vote on whatever we decide to add, and they would have to trust that whatever we come back and put back into law will become law in terms of how we charge children for crimes that can go to adult courts.
Thank you, Senator Barrow.
Senator Duplessis on a question for the bill.
Hello, Senator. Okay, I'm looking at the bill. What I see currently in the Constitution are 15 separate crimes that are enumerated in the Constitution that were voted on, I believe, in 1974.
I think you got that right.
First or second degree murder, manslaughter, aggravated rape, armed robbery, aggravated burglary, aggravated kidnapping, attempted first degree murder, attempted second degree murder, forcible rape, simple rape, second degree kidnapping, a second or subsequent aggravated battery, a second or subsequent aggravated burglary, a second or subsequent offense of burglary in an inhabited dwelling, and then a second or subsequent felony grade violation of the Uniform Controlled Dangerous Substance Law. I heard you mention to Senator Barrow potentially adding sex trafficking. What other crimes might be added to this by this legislature if we were to change the law?
I'm not going to go too far down that trail with you, Senator, simply because that's not the intent of this legislation. I think those conversations on the most serious and violent crimes that we would all agree as a legislature, and after listening to stakeholders, I think those conversations would happen after the fact. I did mention sex trafficking because that was brought up in committee.
Okay. I noticed a similar theme in your constitutional amendment and one that we just did with Senator Morris, where we're going to change the Constitution, but we don't really know where we're going. We just want to change it, and then we'll vet and discuss and figure it out later. So I noticed a similar theme. Let's talk a little bit about how young these offenders could be if we change the law such that any crime in addition to the 15 that I just read could be added, right? And then the legislature, it could be someone who's no longer, it could be somebody other than you and me, right? A future legislature they decide that they want to add certain crimes that we couldn't envision, because again, you don't want to go down that hole, right? That means that you could have a crime that some of us may not consider the most violent of offenses, because I read some pretty bad stuff here. I'm trying to see what else there might be. But that would mean that that crime could be added by the legislature, and then a DA would then have the ability to charge, say, a 12-year-old with that crime?
No, sir. I believe if you look in the Children's Code in the 305, it would be at 15 years old.
It's only above 15.
Only above 15.
Okay, so it doesn't go below 15. So between 15 and under 17, because we just raised the age. Okay, we got rid of raise the age. I know you mentioned a few times that we're an outlier. Did you know that Louisiana is one of only 4 states in the country now where you can be charged as an adult you are automatically charged as an adult at 17? Does that not make us an outlier?
I can't say that it does or doesn't. I'm saying that we're an outlier as it pertains to the language being in the Constitution.
Okay. Well, I would think that being one of 4 states in the country that charges 17-year-olds as adults automatically, that would probably make us an outlier. But moving on, what are the results of us reverse and raise the age since we've done that just a few months ago? What have we seen as a result of that, of the law that you pushed for? Reversing raise the age, bringing it back to 17. What has been the outcome of that?
Yeah, it's you know that it's been very recent since we've done some of that, and I can't speak to all the outcomes from, all the positive effects from it, but I do hear from local law enforcement nothing but gratitude and thanks, and families as well, gratitude and thanks for us addressing the juvenile crime epidemic that we have in the state. Hopefully a year from now, and then moving down the line, we'll all be able to be proud of some of the successes that we've had. But I don't think that this has any bearing on the trail that you're going down now, because all we're doing, we're not changing the law with this. We're just
changing the Constitution.
Just removing the language from the Constitution. The people ultimately will decide whether we want them. They want them to remove it or not.
So when you say I'm going down the trail, I would hope that you would agree that we're both trying to go down the trail of addressing the issue of crime in our community, and the crime specifically as it relates to juvenile crime. Would you agree that crime is down across the state of Louisiana?
I don't have statistical data in front of me, but I do think that it's getting better.
Did you know I was recently at an event put on by the Metropolitan Crime Commission in New Orleans? Might have been 1,000 people there, give or take, or maybe 700, I don't know. Governor Jeff Landry spoke, and he touted the fact that crime was down in New Orleans. Did you know that?
Well, I'm thrilled to hear it.
Okay.
Yep.
All right. So did the DAs ask you to bring this bill? I know you said that they would support it. Did they come to you and say?
No, they didn't.
Okay. And you said law enforcement was thanking you for the bill. Did the sheriffs ask you?
I'm just going to flat out answer your question. This has been, conversations about surrounding dual sentencing, or what we can do to address the most egregious crimes, have been going on since I've been here in the legislature. And what we have continued to run up against is the constitutional language. And, just think about it, Senator Duplessis. If we would vote to add, say, sex trafficking, we would have to pass that by 2/3 in both houses, wait for a statewide election. If there's no statewide election, there would be a cost to the people of, I don't know, $12 million. And so we might be a year out or more before we actually get the people to decide. Oh, wait, then a little later, you and I decide as a legislature, maybe we need to add, I don't know, another crime like, maybe it's carjacking, or maybe it's something even more egregious than that. Maybe it's a drive-by shooting. So we would add bring up another proposition.
Would a drive-by shooting not be attempted first-degree murder or first-degree murder? That's already listed here.
If a drive-by shooting has a murder involved in it.
Okay. Well, it would be it could be attempted first-degree murder.
But anyhow, the point is, I'm speaking to the logistical nature of it. So we'd want to add another crime to it. And so we'd vote on it 2/3, maybe a year later, and we'd bring it back before the people. And then maybe 2 years later, we need to add another crime, or maybe we need to remove a crime. And so we go through the whole legislative process again and bring it before the people. That's a very taxing and tedious situation to address some of the most violent crimes in an ever-changing juvenile crime landscape.
Okay, so you're saying that some of the most violent crimes.
I'm saying that this would help
I
us.
read 15. I heard sex trafficking. I heard maybe drive-by shootings or one or two others. All right, let's talk about what do you anticipate? Because again, I know you again, similar to the last bill. We want to change. We don't want to change the law. We just want to change the Constitution. Maybe the law will change after. Maybe it won't. So I guess this might be a hypothetical that you probably don't want to answer. But I would hope that we could try to just have an honest discussion here about what you think this may cost the state. Because I don't know what they said in your parish, but I heard from my local sheriff who's already dealing with the effects of lowering the age again, and they're talking about the additional costs, the logistics that are added on to now having 17-year-olds housed in adult prisons. That I've heard from my sheriff that this bill will have detrimental impacts from a cost standpoint, costs and logistics. Have you not heard that from any sheriffs across the state?
First of all, this bill doesn't cost anything.
No, this constitutional amendment does not cost anything now, but it's going to open the door for the legislature to come back and pass laws that will cost something.
And
so can we stop
if
that?
the legislature would, and then the second thing is the cost of an election. Every time we want to add or change the provision, the language in the Constitution, there's a cost associated with that too. But let me finish answering your question. And then on top of that, if hypothetically we would add sex trafficking, and if hypothetically a juvenile was, I don't know, a 16-year-old was sentenced as an adult, which would be still, no matter what, if you added it, would still be at the discretion of a prosecutor. I believe that there would actually be a cost savings.
Okay.
Yeah.
What is the ultimate value if there's a crime that's not enumerated here? If there's a crime that's not enumerated here that a young person under 17 commits, and it's now been added to the Constitution, well, it's now been added to law in the future. What is the value of charging that young person as an adult? What do we gain?
Well, I think it depends on the crime. If the most serious of crimes should have the most serious
outside of this 15
of consequences, it depends on what it is. And of course, you're bringing a hypothetical, but the endangerment to society. I mean, the list could go on and on.
Are there not already punishments in place for 15-year-olds who commit serious offenses?
Well, yes, there are. There are punishments.
What is the value of any crime that's committed outside of this list, right? This 15. Of charging a young person as an adult, and it's not already on this list. What is the ultimate value? We're asking the people to change the Constitution just because maybe one day we need to charge 15-year-olds as an adult. What is the value? How do we benefit from that?
Well, if it's not on the list and it's an incredibly egregious crime with a terrible consequence of that crime, that juvenile was charged as a juvenile, and that juvenile may be charged at 16 years old and only serves until they're 21 years old, because juvenile life is 21.
And you're saying there are crimes that terrible that aren't on the list that I just read out?
I would venture to say yes.
Okay, what are they?
Well, we mentioned a few of them.
Can you say them? Because you didn't want to go down that hole.
Can I mention Miss Linda Frecky that was carjacked and drugged to her death?
And those people they were charged as adults.
One individual.
Okay.
Yeah.
Yeah, but I think the message was sent, and I think the DA exercised his discretion in that horrible instance, charging those young people as adults.
Because there was a death involved. Yes.
Okay.
But I do. Let me just say this out of respect, because I know at the end of the day, I believe that you and I truly care. We care about the juveniles. Like, we care about the people, behind the charges, right? We care about the people behind the charges. And I think you've seen enough of me to know that I care about the people. I'm not just punitive, Senator Duplessis. I believe in a measure of love being applied just the same.
So you're saying we love them by sending them to adult prison?
No, don't take me there.
Okay.
Don't take me there, because
question.
I'm speaking to the humanity in both of us right now. So let's stay on that. What I'm offering, what I'm saying is, if we do pass this, and the people ultimately approve this measure, that I will work with you and anyone and any stakeholder, whether it's in the legislature, outside of the legislature, to make sure if the time comes that we're making the best decisions and have the best solutions that would be brought forth while I'm here and be brought forth and proposed to 2/3 majority in both houses.
Why do juveniles commit crime, in your estimation? Why do young people commit the kind of crimes that we're talking about?
We live in a fallen world, Senator Duplessis. Why do people do what they do? I don't know. I mean,
is there anything else that we could do to try to stop these young people from committing these crimes?
I'd like to pose that, pose some of those questions.
Is there anything else that we could do?
Well, you and I both know that there's a lot that we could do.
Okay.
There's a lot societally
like
that we could do.
What could we do other than just saying, all we can do is send them to adult prison? Is there anything else that we could do?
Well, today I have a provision before you that is a constitutional amendment, and it basically puts Louisiana in line with 49 other states by removing language from the Constitution, and we can continue to have those conversations. Even if it doesn't pass, want to have those conversations with you, but if it does pass, we can continue to have them as well.
Thank you.
Thank you.
Senator Presley, question on the bill.
Thank you, Mr. Acting President. Senator Cloud, my reading of the Children's Code along with the Constitution is that this would only apply now to 15 and 16-year-olds. Is that correct?
Up to under 17. Under 17.
Under 17, but under I believe you testified or stated earlier that that the Children's Code requires this to only apply to 15 and older, correct?
Well, he had said the senator had said 17. I mean, with the lower the age, it's the max is 17.
Right. So we've
15 to 17, up to 17 years old, this would apply
but
to.
under 17, I mean, 17's already addressed, correct?
Yes.
We did that legislatively.
Yes.
And said that 17-year-olds can be charged as adults now, right?
Yes.
So, in realizing that, along with the Children's Code that states that only 15 and older can be, this would apply to.
Okay.
These 15 crimes that are currently listed in the Constitution would only apply now to 15 and 16-year-olds, right? Okay. Just want to make sure that we're not talking about 12 and 13-year-olds or 14-year-olds, right?
Thank you for that.
Just talking about 15-year-olds. Okay. And my recollection, and we've been here a lot this year, right?
That we have.
And a lot of the conversation that we've had so far during the sessions is dealing with crime. And one of the things that we've addressed is the need for additional space in our juvenile facilities, right? Mm-hmm. And I think you brought that legislation. Is that correct? Where are we on that aspect of things?
We're moving right ahead. We've taken applications. What we're hoping to do, applications from different entities, different sheriffs, different juvenile regional authorities that have established themselves, that they're putting in grant applications right now, and we're vetting them, and we'll be hopefully, having some selected for funding and approval through the Joint Budget Committee before too long.
And the goal there is to ensure that we have facilities for juveniles that commit violent crimes and crimes that the courts believe they need to be held and incarcerated for, correct?
And regional bed space.
Sure.
Mm-hmm.
Has prior legislators, let me back up. I believe you stated earlier that the list of crimes that are currently in the Constitution came in the early 70s. Is that right?
Yes.
Have prior legislators gone through and tried to add additional crimes since that time?
I don't know.
Do we know if any have been added to that list since the early 70s? Okay. Thank you.
Thank you.
Senator Jackson Andrews on the floor, please.
To the floor, Mr. President.
Floor on the bill.
Thank you, Mr. Acting President. I rose because I had so many questions on this bill on how similar it was to the bill I authored last year on dual sentencing. The bill I authored was quite different, very different. it only sought to address the number of juvenile rapes we were seeing in adult facilities, to allow for dual sentencing so juveniles who were sentenced to life could spend their time until their juvenile life in a special facility and then be sent to adult facility. And as the staff told me then, we would need something to dual sentence them so that they could spend juvenile life in a special facility. That's all my bill sought to do. With all due respect, Senator Cloud and I have spoken, and her bill is very much different than that. And I want that point of clarity first, because I have been filtering, not answering certain interviews, because somehow people think that this bill is synonymous to the bill I filed, which is not. That's my point of clarity. Then there's going to be a constitutional point to this. I authored an amendment that passed this state that protected the life of children, because we understand that children are live in diverse circumstances, in diverse homes, and some of those circumstances are criminal in nature. And I did that for a number of reasons. So I do believe when I look at the Constitution and the list of crimes, if other crimes are being committed that are more as heinous as the crimes listed, then the proper vehicle for this type of legislation to take a scalpel to the problem we're facing while still protecting the lives of children and looking into the special circumstances of those children would be to offer a constitutional amendment that adds the crimes that we and Louisianians across the state believe should be added. We reduced, or I didn't vote for it, but you reduced the age that a person could be tried as a juvenile on last year. I haven't heard from any of my DAs telling me they need any more discretion than they have now to address the juvenile crime rate that is in fact going down in the state of Louisiana. But what I do hear from is a heart that says that at some point we cannot make it political that what crimes juveniles are tried in is based on who's elected at the time. This has always been by vote of the people, looking at the special needs of juveniles in this state. And why it's so important is because we don't know who sits in these seats after us 20 or 30 years from now. Since 1970-something, the Constitution has always dictated what a child in this state could be tried as an adult for. That was for the protection of children. I don't want a schizophrenic Constitution that protects children on one end and doesn't protect them on the other. Now, we can all admit that when we came in here and took our oath for this term, children, adolescents' crime was out of control. There were some measures passed to address that, and the district attorneys are now using it, whether we like it, whether we voted for it or not, and we're seeing a reduction in crime. But I would caution any member of this legislature very respectfully, even my esteemed colleague whom I love, on taking something out of the Constitution that's meant to protect the least of us, and taking a knife where a scalpel should be used. Because if there are crimes that should be added, then amend the bill, put the crimes in, let the people vote on what those crimes should be. If it's going to the people with no enabling legislation, we are divesting the people of their right to protect children. And that's generally how I look at it now, as I've said and listened to the debate. So I rose for a point of clarification on what my bill did, because it was a protection bill that failed. But I also rise now in opposition, because we're taking the people's voice away and how children should be treated in this state. And so that's why I rise for point of clarification and in opposition to this bill.
Senator Barrow, floor on the bill.
Thank you, Mr. Acting President. Members, I rise in opposition of this bill, and I'm going to talk about a few things. First of all, one of the things I want to highlight and point out is when I asked my good friend here if the DAs and the sheriffs supported this measure, she said that the DAs did, and they sent her something this morning, and they were supposed to be sending us something. I can say to you that I did not receive anything from a DA, and when I turned and asked Senator Jack Andrews if she did, she told me no. I didn't have a chance to ask if any of the rest of you received something. But what she did not say is that she received something from the sheriffs. And I can tell you right now that the sheriffs are not happy about having something else added because they are overrunning right now, as has been stated earlier on, by now having 17-year-olds now tried as adults, and they really don't have the facilities. The other thing that really bothers me is the fact that I recently learned that we currently have young people up in North Louisiana housed in a shipping container. And I didn't have a chance to go take a look at it. And I pray to God that it is at least livable and we don't have children living as animals. And I will go check it out and see for myself. But is this what we're going to do? Now, I know this is not what this amendment does, but what it will do, it is going to allow for these type of things to happen. Kids are not born bad. They don't choose their families. They don't choose their situations. They don't choose their communities. They don't choose anything. But they get put into situations where they have to try to survive and live. Sometimes they get caught up in bad situations. I'm not trying to say that a child that commits a heinous crime should not have to pay the consequences. That is not what I'm saying. But what I am saying is we have a responsibility that when that happens, we try to get them back on a path of rightness. Because they got off most of the time because they didn't have the right guidance in the beginning. We need to make sure that we are providing those sources of rehabilitation. Someone recently told me about a young lady that committed a crime, and her family, and it wasn't a crime of violence. I'm just wondering, where is this going to end? But her family could not afford the bond. And guess what? She's still sitting in jail. I want to say to all my pro-life colleagues, because I'm pro-life, and I believe in pro-life from the beginning of birth. Royce asked this question: what can be done? We need to be sure that we are adding more resources to families where children are being born in situations where they don't have control. We're not making those investments. We have not made those investments. I've been here long enough where I've watched where we were going and were supposed to make these investments 10 years ago in the juvenile justice system, and we did not. In the situations that we have in our families today, where there's more drugs, there are more things that kids are being subjected to. We are dealing with technology that we can't control. They're watching and seeing things that they should not see. And then sometimes they just don't have the basic need of having something to eat. We have failed. And I'm going to tell you, taking this right away from the people is not the right direction. There was a question I think that Royce asked the author, my friend, again. This started off with one item that was placed in the Constitution. And then 14 more were added. We can always add more. We can bring it back before the people. And currently, in all honesty, all the crimes that were listed or stated, there's already provisions in the law that allow anyone who commit those crimes to be charged as an adult from the age of 15 on up. So I ask you guys to not take away this right from the people, and let's really come up with a comprehensive way to address the issues of children. No child wants to be in jail. No child don't want to leave their mark on the earth in a positive way, to let the world know that they were here and they made a positive difference. But they can't control the family they are born to, and they can't control the communities they come from. Thank you.
Senator Boudreaux, floor on the bill.
Thank you, Mr. Acting President. Members, I rise in opposition. And Senator Barrow, I did get an opportunity to receive this morning a couple calls from several of my district attorneys in the district who told me that they supported this bill and would like me to support it. And my response to them was about timing and in substance. And I told them, you know, we had just finished a crime session earlier this year. Some of the municipalities that I represent are still dealing with the aftermath of those changes that we made in the crime session. We are now transporting young people to Mississippi at the burden of local government. They have been told we will address it. So my response to a couple of the district attorneys this morning was, let's address it all together. Let's make sure we address what's already been changed. Now we're talking about additional change to the Constitution. As was stated earlier, the tax session alone is complicated. So we add additional factors to that by bringing a bill of this substance, which the author is entitled to do. But we also know there's always unintended consequences when we bring things. The data, as has been stated, has not been defined. In fact, the bills that we just passed this spring, the ink has barely dried. And here we are continuing down this slippery slope to make major changes. And there's no one in this chamber that condones violence, whether it's juveniles or adults. But as always, when there are difficult issues and difficult times, you try to get all of the information possible before you do it. And you, as well as I, received a note from Tom Costanza with the Louisiana Conference of Catholic Bishops. And I'm not going to read it to you because you've already seen it. But the gist of it is that most of these crimes are currently in the Constitution for a reason. And that reason is to set the bar to charge juveniles as adults as they should be. And the intent of the framers of our Constitution would not have a child just be locked up for any reason. We are failing to meet that threshold that I believe the Constitution has protected today. Tom, in his note, goes on to talk about, again, the rehabilitative and restorative rights of juveniles. We do know there is data. It is more expensive to incarcerate them than to educate them. And here we go again. We want to add more to that exhaustive list. But the conversation when it comes to how do we rehabilitate these people? How do we change the lives and the communities that they come from? So I oppose the bill at this time and its purpose. because I think we need the district attorneys to come during a regular session. And we need the sheriffs to come during a regular session and sit at the table and answer questions. And I think we need to step up for our municipalities and find out when are they going to be made whole for the changes that we previously made on transporting people to other states because we don't have those facilities. And I know we're working on it, but let's get some things done before we get too far down the road. Let's look back in that rearview mirror and realize that one day, one of these 15, 14, 15, 16, 17-year-olds is going to be somebody in our family. And you know what we're going to tell them? Well, that's the law. I can't do anything about it. But just like healthcare and everything else, until it's somebody close to home, we don't get it. I'm asking that we put the pause on this. Let's study this. Let's get the empirical data, and then we will know what the costs down the line will be. There is no fiscal note for doing this today, but you and I both know as changes are implemented, systems are diverted, there is a price tag. Nothing is free. Thank you.
Senator Duplessis, floor on the bill.
Thank you, Mr. Acting President. You know, I did not intend or have in the cards to come down here and be involved in an emotional debate around juvenile crime during a special session on tax reform. I thought we had done all of that in this crime session, thought we had done all of that in the regular session. In the regular session, I was asking, well, didn't we have a crime session before the regular session? And now here it is, we're in a tax session because we absolutely have to change the Constitution because juvenile crime is that bad in the state of Louisiana. We all know that's not the case. Juvenile crime is way down in the state of Louisiana. Crime is way down in the state of Louisiana. We can continue to cite the worst of the worst in terms of the cases that, the crimes that happen in various communities, but we fail to acknowledge that there are already laws on the books to address these young people when they make mistakes, which young people do, because none of us were ever young before. I want to correct something that was said. I asked the question around the lowest that the law would allow a young person to be transferred. That the law actually allows young people as young as 14 years old to be transferred to adult court for certain crimes. The law already covers what needs to be covered in terms of holding young people accountable. The question is, what are we doing to hold ourselves accountable as a society, as lawmakers? When does it stop? I mean, why don't we just keep going? Why don't we change the law to say, you know what? Doesn't matter how young you are. 12-year-old, 10-year-old, 7-year-old. You're doing adult crime, you're going to do adult time. I mean, that's where we are. That is where we are. I think we need to own our own failures and stop blaming everything on young people. Now, there are young people who absolutely need to be held accountable. And guess what? They are being held accountable. I can't understand for the life of me why we would undo the Constitution in such a rushed fashion with zero data, zero asks from law enforcement. They haven't asked for this. Nobody's asked me for this. And I live in the community that supposedly has all the crime. Supposedly. So we're gonna make such a drastic decision. These laws, these enumerated crimes were specifically put into the Constitution for a reason. Because we decided that children should be treated as children and adults should be treated as adults. But this constitutional amendment, when it passes, is saying that there should be no difference. We're going to leave it up to a body who we don't even know is going to serve here sometime in the future to make the determination as to what crimes should apply to 15-year-olds, 14-year-olds. irrespective of what happens to those young people when they're in there with other adults. This is a bad move, a really bad move. And while we may have similar intentions, I can view this as no other way than just giving up on children. Because by giving up on children, we're saying we're going to treat them all as adults, and we're not going to do our part as a society, as policymakers, to address what's really failing. This is not going to do a single thing to deter crime. In fact, it might make it worse. I oppose this measure. Thank you.
Senator Mizell for the floor.
Thank you, Mr. President. I've sat there and I've listened, and I consider myself hard on crime. I've voted for every crime measure since I've been here. One of my best friends at home is my sheriff. And I'm asking him, have you looked at HB 2? And I totally respect you. I know how strongly you feel about this. We are hard on crime, but I don't think we've ever acknowledged how hard we are on the children of this state. We make it hard for them to succeed. We put tops in, but we send them to school without ever seeing a teacher. We let the mama stay home with no money and no child care. We'll never get out of poverty because we will not fund early childhood education, and we're going to sit here and talk about how much more money we need to put into corrections. It is really, it hurts me because I'm so frustrated at how strong we are on a vote like this and what begging we have to do to bring anything up that benefits the child on the other side. I'm pleading with you. I feel like everybody's mostly decided, feel as strongly about early childhood education and doing something about the situations. Most of these kids can't read. They can't read. And we're expecting them to be part of a workforce. We're all working for tax reform to bring a workforce here, but we're not investing in the kids that are going to hopefully get out of poverty and change the perception of the state. The perception of the state, come to my district. Come to my district and see the poverty, see the hopelessness, and you'll see the perception of this state. And I'm just asking you to take whatever you're thinking today on the justification to trying to find a fix that involves the kids on the other side. Thank you.
See no more questions. Senator Cloud, to close on your bill.
Thank you, Mr. President. Look, these are hard conversations, members, and they should be. There should be vigorous, robust debate, and there should be emotions involved because we are talking about young people. I want to first point out Mr. Tom Costanza, precious Mr. Tom, and his note, and acknowledging my personal commitment to enhance the lives of young people. And I truly believe the Lord has put me in this place dealing with juvenile crime, dealing with juveniles for a reason, because it is a mission field. It is a mission field, and it's one that we're missing. But I do want to also point out that in paragraph 2, it said SB 2 would allow any child at any age to be charged with any crime, and that's not the case. That's not what this bill does, and certainly would never be the intention of the legislature. One thing that I want to address in my closing is a question that Senator Duplessis asked and Senator Barrow reiterated, and it was, what can we do and what should we do? Let me show you these notes that you have. And the people that sent these notes in this room and that are watching, let me tell you what you do, members, and all of you do-gooders. Show up. Show up. because I'm showing up at the juvenile facilities. I'm visiting with the kids. I'm listening to them. I'm listening to their backstories. I'm trying to understand what's going on. I'm listening to the people that are working to keep them safe in the facilities, the correctional officers who are being spit on, who are being beat, who are being hurt. I'm listening to the younger juveniles that are 14 years old sleeping next to older, 18, 19, 20-year-olds, afraid. I'm listening and watching, and that's why I've brought legislation in the past for the tiered system to protect them and to help them and protect communities. And that's why I've advocated for vocational training and job skills training. And that's why I'm calling out to you right now. Do you want to know what to do? Show up. Churches, show up. Mentor these kids. Where are you? Senate members, House members, where are you? Are you showing up? Then why are you complaining? Why are you saying that because we don't want these children to create more victims? Like, we do love them enough that they're going to one day wake up and realize that they have to deal with the consequences of their actions, and it is going to hit them hard. It is going to hit them hard when it does hit them. Just because we love them and we want to equip them, we still have to set boundaries, and there has to be consequences. This is not me loving them any less. This is me loving them enough to say, you can't create victims. There are boundaries. There are limits to what you can do. This bill, all it does is put Louisiana in line with 49 other states so that we could have deliberative conversations. But you want to know what to do? I know. Show up, because I go. And all the places that I have been, I have only seen one person there. We can get you records. I can get them from OJJ. I've been to pre-adjudication facilities. I can get you records of who visits. Nobody. But everybody comes over here fussing about what we do and the decisions that we make. You better be prepared when you come to committee, because I'm going to want to know how often you've been and where you've been, because we need you. I believe you care. I believe you care, but actions will prove it so. Mr. President, I have no more questions, and I ask for favorable passage.
Senator Cloud moves final passage of Senate Bill 2. When the machines are open, all those in favor, yes. Opposed, no. Madam Secretary, open the machines. Vote your machine, members. Vote your machine. Madam Secretary, close the machine. 28 yeas and 9 nays, and the bill is finally passed. Senator Cloud moves to reconsider the vote, which will pass, and lay that motion on the table without objection.